Good morning and welcome to the Public Service Commission of South Carolina. It is Monday, May 20th at 10 a.m. We are here in docket numbers 2023-388E and 2023-403E for hearing notice to begin this morning at 10 a.m. I'm going to take a roll call of commissioners. We have Vice Chair Powers, Commissioner Thomas, Commissioner Carolee Williams, Commissioner Caston, and Chair Belser. A note for the record that Commissioner Justin Williams is on military leave. Let me recognize our staff counsel, Ms. Mosier, to read the dockets.
Thank you, Madam Chair. Good morning, commissioners, and good morning, parties. We are here today for the proceeding in docket number 2023-388-E, the application of Duke Energy Carolinas, LLC, for an increase in electric rates, adjustments in electric rate schedules and tariffs, and a request for an accounting order, as well as docket number 2023-403-E, the petition of Duke Energy Carolinas, LLC, to extend an accounting order to continue regulatory asset treatment for ongoing grid improvement plan costs. This proceeding has been scheduled for today, May 20th, 2024 at 10 a.m. Madam Chair, I believe all parties participating in this matter are available and the docket is in order. Thank you.
Thank you, Ms. Mosier. Let's take appearances from the parties. Who's representing Duke Energy Carolinas, LLC?
Good morning, Chair Belser, Vice Chair Powers, members of the Commission. My name is Kamal Robinson, appearing on behalf of Duke Energy Carolinas, LLC. With me today are Ashley Cooper of Baker Donaldson, Karan Mehta and Melissa New of Troutman Pepper. I and Mr. Mehta have been admitted pro hoc vice in this proceeding. Additionally, Chair Belser, if it may please the Commission, I would also like to introduce Ms. Erica Green and Ms. Janice Renzi, who will ensure that summaries, exhibits, and any other handouts are properly provided to the Commission and to the parties throughout the proceeding. Thank you.
Thank you, Mr. Robinson. Interveners, South Carolina Department of Consumer Affairs.
Good morning, Madam Chair, Vice Chair Powers, members of the Commission. I'm Roger Hall, Deputy Consumer Advocate with the Department. Also with me is Jake Edwards, Assistant Consumer Advocate. Our Administrator, Carrie Leibarker, is also an attorney of record, but she was not able to make it this morning and will likely be joining us later this week.
Thank you, Mr. Hall. South Carolina Energy Users Committee.
Madam Chair, I'm Scott Elliott. I represent the energy users in this docket.
Thank you, Mr. Elliott. South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, and Vote Solar.
Good morning, Chair Belser. My name is Kate Mixon. I'm representing SACCL and Vote Solar, and with me today are Thomas Gooding and Emma Clancy.
Thank you, Ms. Mixon. Walmart Incorporated. You're on, Ms. Eaton.
Okay, just making sure it didn't light up. Good morning. My name is Stephanie Eaton. I'm here on behalf of Walmart. Thank you.
Thank you, Ms. Eaton. And Office of Regulatory Staff.
Good morning, Madam Chair, Vice Chair Powers, and Commissioners. My name is Chad Torrey on behalf of the Office of Regulatory Staff. I'm joined today by my co-counsel, Lenise Mitchell. Did also want to indicate that Joshua Austin, Donna Rainey, and Cassidy Murphy are also attorneys of record in this case. Thank you.
Thank you, Mr. Torrey. And I understand that the South Carolina Small Business Chamber of Commerce and CMC Recycling are not appearing at the hearing. Is that correct? Is that the party's understanding? Thank you. I see some nods. Good morning, Mr. Knapp. Preliminary matters. Kind of scared to ask.
Chair Belser, a few preliminary matters. One, there is a pending motion to strike that the company did file of certain testimony of DCA witnesses. Wanted to understand from the chair how you would like to proceed with that.
We'll rule on that in the final order.
Thank you, Chair. I will turn to the ORS to see if they have any preliminary matters or any of the other parties.
Mr. Torrey?
Thank you, Mr. Robinson. Madam Chair, yes, I believe as the Commission is aware at this point, the company, South Carolina Small Business Chamber of Commerce, South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, and Vote Solar. South Carolina Energy Users Committee and ORS have entered into a settlement agreement that has been filed. I believe it was filed Friday afternoon for your review. As between the settling parties, the settlement agreement would resolve all issues in the case. I am happy to share some of the highlights of that settlement agreement and introduce it into the record at the appropriate time.
Any objection to receiving the settlement agreement into the record as the next hearing exhibit?
Madam Chair,
Mr. Hall?
I don't object to the entrance of the settlement agreement into the record. Acknowledge it's just, I will say, due to the late filing of it, we have not had a chance to fully review it, and so would just like to acknowledge that for the record. I do have additional preliminary matter related to the settlement testimony and Duke's proposed revised schedule that
We
I'd like
hadn't
to have
gotten to
addressed
that
at
one
some
yet.
point. It's sort of all related, but again, I don't object to it. Just want to acknowledge that the department would like a little bit more time to review it.
Okay, we'll get to that in just a second, but right now I just want to see if there's any objection to admitting it as a hearing exhibit, and there is none. Okay, so the settlement agreement that was filed, I think Friday morning, will be, I have hearing exhibit 8. So we will mark the settlement agreement between Duke Energy, Office of Regulatory Staff, CCL, Vote Solar, small, or SCEUC. Did I miss somebody?
South Carolina Small Business Chamber of Commerce.
Small Business Chamber of Commerce will be marked for identification as hearing exhibit 8 and admitted into the evidence of this case. Okay, is that it from you, Mr. Torrey?
Yes, Madam Chair, unless the commission would like, again, just a brief overview of the settlement. I know that you've had it for a while, and so I'll leave that at your pleasure.
Yes, please go ahead. Is that going to mess up anybody's preliminary matters? We can finish preliminary matters and then go to that, but now's a good time, Mr. Torrey. Thank you.
Thank you, Madam Chair, again, and commissioners. The company, or the settlement agreement, is the product of earnest good faith and complex negotiations between many stakeholders with diverse interests. Each of the settling parties made compromises from their original positions in an effort to achieve a balanced resolution of all the issues in this rate case. Now, none of the settling parties got exactly what they wanted. I believe such a reality is the hallmark of a good compromise. I did want to highlight the principal issues addressed by the settlement agreement, if I might. The settling parties compromised to reduce the requested return on equity to 9.94% and a capital structure for rate-making purposes of 51.21% equity. The settling parties agreed the company would take a permanent one-time disallowance of $17.245 million on a South Carolina retail basis in coal ash basin closure costs incurred through December 2023. Settling parties also agreed that the company would permanently forego coal ash basin closure costs of approximately $36 million on a South Carolina retail basis, sought by the company in this proceeding that were not allowed for recovery by the Commission in the company's 2018 rate case. With respect to the Duke Energy Plaza, the settling parties agreed to accept the company's inclusion of a one-time permanent $50 million system plant in-service disallowance contained in its application, in addition to a one-time pro forma adjustment for future sublease and parking revenue of $3 million on a South Carolina retail basis. You may recall that the Commission consolidated the company's rate case with its petition to extend regulatory asset treatment for its grid improvement plan. The settling parties agreed the grid improvement plan deferral will terminate effective August 1st of 2024. Settling parties also agreed the company would remove $2.5 million plant in service on a South Carolina retail basis of targeted undergrounding investment that's part of the GIP. The settlement agreement also contains provisions that would require the company to improve upon and report to the Commission and ORS its activities concerning vegetation management and its storm reserve. And those are just some of the components of the settlement agreement. And with the company and ORS filing settlement testimony, I'm quite certain that you will learn more details about that as we proceed. The settling parties agree that the settlement agreement is reasonable, it's in the public interest, in accordance with applicable law and regulatory policy. Settling parties respectfully request that the Commission approve the settlement agreement as filed. Thank you very much.
Thank you, Mr. Torrey.
Chair, I will state the company does also have some comments from the company's perspective on the settlement at the appropriate time.
Go ahead, Mr. Robinson.
Thank you. Chair Belzer, Vice Chair Powers, members of the Commission, we appreciate the opportunity to come before you this morning. The company is proud to present, along with the settling parties, the Commission with a settlement agreement that is comprehensive in the scope of issues before the Commission in this proceeding between ORS, South Carolina Small Business Chamber of Commerce, South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Vote Solar, and the South Carolina Energy Users Committee, as well as the company. Walmart and CMC Recycling, although not parties to the settlement agreement, have indicated they do not oppose it. In other words, all parties support or do not object to the settlement agreement, except for the Department of Consumer Affairs. To begin, South Carolina has a strong public policy in favor of settlements. In this context, the General Assembly has given ORS the duty and responsibility to try to resolve cases in the jurisdiction of the Commission. Recognizing this important charge, the parties got to work and were able to resolve complex, highly contested, fully litigated, and sincerely disputed issues. To be clear, not everybody got what they wanted, but this is the hallmark of a great settlement. Indeed, there are commitments and terms that would not exist but for the achievement of settlement, as I will discuss in a moment. Now, I would like to make a few general remarks about the settlement. Before I do, however, first I'd like to personally, as well as on behalf of the company, thank the parties for their collaboration and compromise to achieve this result. This case was complex, and so I note that this settlement comes only after a full and detailed exploration by all the parties of the contents of the company's application, resulting in over 40 witnesses, voluminous amounts of testimony, thousands of data requests, a deposition taken, and several motions filed, some even argued before this Commission. While I certainly cannot discuss the details of the negotiations, I can say that it is with the extremely well-informed view by all parties that we decided to engage with each other over the course of a month to evaluate whether a compromised resolution could occur, which we achieved. So now I will briefly turn to some key features of that settlement. Notably, the settlement provides for a significant reduction, approximately $83 million, from the company's file position, including but not limited to a significantly lower ROE opportunity than the company originally proposed, a significantly lower capital structure than the company originally proposed, reduced coal ash cost recovery, reduced level of carrying costs during the deferral period on deferred costs, such as coal ash and grid, reduced level of targeted undergrounding cost recovery, discontinuance of the grid improvement plan deferral, reduced recovery of Duke Energy Plaza costs, a reduced recovery of incentive compensation and benefits, and several more. It is for these reasons that we believe, while not all parties support or object or do not object to the settlement, that the issues raised by all parties in this proceeding are adequately represented in the settlement before you for consideration. The settlement agreement resolves all disputed issues among the settling parties. The agreement and all issues among the settling parties, if approved by the Commission, will significantly reduce or eliminate lines of cross-examination, evidentiary objections, and the presentation of competing live testimony from multiple parties on all of these issues, creating efficiencies and promoting judicial economy. In addition to resolving the complex issues I previously discussed, ending costly litigation and providing finality, as referenced above, the settlement specifically provides for a 26% lower revenue impact than that requested by the company, and also provides that the company will make a $2 million shareholder contribution to fund a low-income affordability study in South Carolina and low-income weatherization programs. And just as important, the settlement provides a path for the company to continue appropriately investing and maintaining electric facilities and providing high-quality electric service, which is a matter of public interest and a benefit to all customers. And we believe the adoption of the settlement would help the company attract the capital necessary for its growing operations in the state on reasonable terms. The Commission has certainly adopted settlements over the objection of non-settling parties before, nor is the Commission alone in this regard. Utility regulators have approved non-unanimous settlements across the country. So has the Supreme Court of the United States. It is meaningful when almost all parties heavily invested in evaluating all aspects of the company's proposal come together and present to the Commission a settlement that covers all issues between the parties, the settling parties, particularly when it includes positive provisions that this Commission could not award absent a settlement. Further, adopting this settlement will allow the company to keep up with the demand for transmission, generation, and distribution occasioned by the transformational growth South Carolina has experienced in recent years. We look forward to putting up our case and presenting Mike Callahan, our South Carolina State President, Retha Hunsaker, LaWanda Jiggets, Chris Bauer, Morgan Beveridge, Jim Coyne, Tim Duff, and any other witnesses the Commission or the parties would like to hear from to engage in these important discussions with the Commission. As our witnesses will demonstrate, substantial evidence in the record will overwhelmingly show that the terms of the comprehensive settlement are just, reasonable, and in the public interest. And at the appropriate time, we, along with the other settling parties, will therefore ask the Commission to adopt the settlement agreement in full. Thank you.
Thank you, Mr. Robinson. I'm going to go to the settling parties first. Ms. Mixon, or any comments?
Yes, good morning, Chair Belser, members of the Commission. Thank you for the opportunity to be here today. On behalf of the South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, and Vote Solar, we are pleased to offer our support for the settlement agreement. As you've heard from others, the parties have worked diligently over the past few weeks to reach an agreement that all the settling parties can support. CCL, SACE, and Vote Solar are especially pleased that under the agreement, the company is committed to taking a number of steps to enhance its reliability reporting and improve its low-income energy efficiency offerings. First, the company is committed to report several additional customer-focused reliability metrics, which specifically capture the number and frequency of long-duration service interruptions. They will also evaluate reporting these and its other reliability metrics geographically at the zip code and census tract levels, which can be used to ensure the company's service is uniform across its service territory. By combining these customer-focused metrics and geographic reporting, we hope that Duke will be better able to capture any variation in reliability that occurs within different geographic areas and across different socioeconomic groups within its service territory. With respect to low-income energy efficiency, Duke is also committed to evaluating improvements to its Neighborhood Energy Saver program, to filing its income-qualified high-energy use program in DEC territory if the recently approved DEP pilot is successful, and to helping its customers access Inflation Reduction Act rebates and opportunities. Finally, we appreciate that Duke has committed $2 million in shareholder funds to go towards two critical initiatives. First, they've committed $1 million to go to local weatherization agencies for critical health and safety repairs that are often a major barrier to customers being able to participate in the Weatherization Assistance Program. Second, the company's committed an additional $1 million to go toward a low-income affordability working group and study, which will look specifically at how energy-burdened customers are using energy, and then working to develop programs, initiatives, tariffs, et cetera, that could help those customers afford their energy bills every month. Exactly what that process will look like or what the outcomes will be, we don't know yet, and part of that is by design. In our experience, the best stakeholder process is one where the stakeholders themselves have a say in how that process unfolds. And we also think there are other groups like energy justice organizations, community groups, et cetera, that should be involved in the process. We're hopeful that having this dedicated forum to study affordability in Duke's territory will have many benefits to its customers, especially since the study's costs will be funded by shareholders. And I should add, if the study process ends up costing less than the $1 million committed, any excess will go towards health and safety repairs, as I mentioned earlier. So thank you again for the opportunity to be heard today, and we look forward to presenting our witnesses' testimony later in the week. Thank you.
Thank you, Ms. Mixon. Mr. Elliott, do you have any comments?
Just briefly, Madam Chair, I would echo the remarks of Mr. Robinson and Mr. Torrey when they explained to the Commission that this settlement is a compromise of sincerely held and hard-fought principles, and I believe it's in the public interest, and we would urge you to approve it.
Thank you, Mr. Elliott. Ms. Eaton, while not a signatory to the agreement, I understand that Walmart does not object. Do you have any comments?
Our only comment, in addition to being grateful for having the opportunity to present our clients' witness and testimony for this commission and the ability to work with the parties in negotiations. We did participate in the negotiations. We did not sign the settlement agreement, but we don't oppose it because Walmart does recognize the significant reduction in the overall request that was made, the revenue increase that was made in the original application, as well as the change in the ROE and some stakeholder issues and meetings that the company has promised to engage in with its customers. And so overall, the impacts are reasonable in the perspective of Walmart, so they decided not to oppose the settlement agreement. Thank you.
Thank you, Ms. Eaton. Does that cover all the signatories that are present? No small business has been excused. Mr. Hall, any comments? We understand that DCA has not signed on and will proceed with presenting its case when we resume the hearing.
That's correct, and I appreciate the opportunity just to give a few brief words. The Department of Consumer Affairs did engage in good faith negotiations with all the parties in this matter. Our aim in any negotiations or any hearing is to get the best deal possible for residential customers while recognizing the needs of the other customer classes and any other interest groups in the case. Unfortunately, we were just not able to get there in this matter, particularly with regards to rate of return and certain grid improvement plan and coal ash issues. Therefore, we could not join the settlement. Thank you.
We understand that, and that's why we're here. Part of the reason. Okay. Well, we put the settlement agreement into the record. Now, let me just kind of tell you where we are, and I understand that DCA may have some things that you want to address, but as we have stated, the settlement agreement was filed on Friday morning. Settlement testimony came in sometime on Friday afternoon. I know that we're still trying to parse through everything, and I think some of the parties are as well. Therefore, the plan is, unless there's an objection that we need to address, the plan is that we will recess this hearing. I'm thinking until tomorrow, but is that going to provide enough time for everybody?
Madam Chair, respectfully, we would like additional time, and I can address that as part of the other preliminary matters if you'd like.
Well, you want to go ahead and let's address your matters that you want to raise, Mr. Hall?
Thank you again, Madam Chair. I first want to acknowledge that we have not filed any motions on this issue due to the short notice we've had time to prepare, and I believe the commission rules do allow for motions to be made during a hearing. And I also recognize that the settlement testimony has not been officially entered in the record, but I have a couple motions that I want to raise because they are procedural in nature and could impact DCA's due process rights. On that note, I would like to move to strike the settlement testimony that has been filed in the case and to reject the revised proposed schedule that's been submitted by Duke. As an alternative to striking all the testimony.
Mr. Hall, may I get, are you, the revised schedule, was that letter that was filed on Friday afternoon?
Yes, ma'am.
Okay, just want to make ssure I'm looking at the right thing, okay?
As an alternative to striking all the settlement testimony, and to your point about delaying the start of the hearing, we believe the PSC should delay the start of the hearing for at least 2 days to allow the department time to review the new filings, both the settlement and the testimony, in order to determine if there are particular witnesses or provisions in the settlement testimony that should be stricken. If the commission does wish to hear from settlement witnesses, we believe those witnesses should either be presented first or last, and then proceed with the original witness order Duke already presented. I'm happy to elaborate on that further. I don't know if on that note, if you want
Say that last one again. Tell me a little bit more about that.
If you wish to hear from settlement witnesses, or as in the timing of
The
delay.
settlement witnesses, your proposed schedule.
So we're saying if the commission does wish to hear from settlement witnesses, we believe those witnesses should either be presented first or last, essentially bookended around the typical hearing presentation schedule, was putting up all the other witnesses. And we believe that should be the original witness schedule or witness order, proposed by Duke. I have been talking to Mr. Robinson, and we are have some witnesses that we believe can be excused to the extent the commission doesn't want to hear from them. So we're all about judicial efficiency and minimizing the number of witnesses, but we don't believe the revised schedule provides any efficiency, and we believe it certainly is prejudicial to the
Let me just ask this: are you asking that all the witnesses, well, with the exception of the ones you think can be excused, but that the witnesses go up with their direct and rebuttal testimony? I'm talking about Duke witnesses first and other parties, and then also put up settlement testimony? I'm just trying to understand.
So we're thinking through it, and again, with a short notice, there may be more than one way to do this. Our primary issue is what Mr. Robinson and Duke have proposed is that they will put up they have over 20 witnesses. They propose to put up 4 or 5 of them to address the settlement. They then propose to have the department put up its case.
Yeah, I don't like that either. So.
And then to come back with their rebuttal.
Don't worry about that one. I don't like that one either.
Our proposal would be to either hear from the settlement witnesses, again, can elaborate on some issues we have with those based on what we've been able to see so far. Either put up the settlement witnesses, whoever they may be, and whatever their testimony looks like, hear from them, and then proceed with the hearing. Alternatively, proceed with the hearing as normal, and hear from the settlement witnesses at the end.
Okay. Anything further?
If you may, I have a few more minutes in support of my motion.
Sure.
Okay. So first, first I would say, this is not a motion we're making lightly, but due to the potential impact on our due process rights, we felt it was necessary. In past cases, it's a little bit of background. In past cases, I've recalled that partial settlements or settlements where all parties do not join were called stipulations. That made sense to me as they were not true comprehensive settlements. Some examples that came to mind are the Palmetto wastewater case in 2021, and more recently, the Dominion gas case in 23. In the gas case, I recall that all issues were resolved by all the parties with the exception of SCEUC and Texacan, and the document that was submitted was entitled a stipulation. Bit of a nuance, but just wanted to point out that obviously we put on the record that we did not join it, but it's not a full settlement. I recall that stipulation versus settlement issue being explained in the past, and not sure if it was during hearings or not, but typically it was explained that we call them stipulations when not all issues are resolved or when not all parties join in. Just a little bit of background. As the commission is aware, the settlement was filed Friday, May 17th at 10 a.m. and it's 51 pages long. ORS emailed the department its one witness, settlement witness that consisted of 5 pages on Friday at 2 o'clock. And that witness generally explains the settlement, its impact on customers, and expressed their support for it. Walmart served DCA with 3 pages of supplemental testimony on May 17th at 4:27 p.m. And their supplemental testimony simply indicates it does not oppose the settlement. On the other hand, Duke served the department at 4:02 on Friday with its settlement testimony. Its filing includes 11 documents. There are 7 witnesses and 4 exhibits. The total of those documents is 328 pages. That includes 54 pages of testimony and 275 pages of exhibits. To make matters worse, they presented their revised proposed schedule at 5:47 on Friday after the close of business. In that, they claim that in the interest of judicial economy, they are submitting a revised roster of company witnesses to present at the hearing that reflects, quote, the narrowing of contested issues resulting from the settlement agreement. As we've kind of talked about, they first proposed to present its witnesses that focus on the issues that are uncontested in the settlement. Again, five witnesses out of 20 plus that they filed in this case. And then they have which we think is a complete disregard for the department's due process rights and the commission's procedural rules. They propose to have DCA present its case before the commission as the only party objecting to the settlement. And again, as they said, but they have been nice enough to make all their witnesses available upon request of the commission and the department. I think the first issue, there are a few things that our motion is based on. First, again, the obvious due process issues. We believe it's improper under 103-842, order procedure, 845 for witnesses, and the PSC schedule in this matter. We also think it's prejudicial under evidence rule 403 and rules 15 and 6 of the South Carolina Rules of Civil Procedure. I want to start with regulation 103-842, order of procedure. That states that applications and petitions, evidence will ordinarily be received upon application and petitions in the following order. 1, applicant and petitioner. 2, other parties. 3, Office of Regulatory Staff. The department relied upon this regulation and the commission's January 25th, 2024 pre-filed testimony letter in preparing its case and scheduling its witnesses. The PSC's January 25th letter states, bold and underlined, these are important required deadlines for documents that must be filed with the commission. On 4/5/6/2024, parties are to submit their order of witnesses they plan to present at the hearing. Again, 3 days before the hearing on a Friday after close of business, the company proposed to change its order of witnesses. Duke's proposed procedural change is akin to a motion filing on the day of the hearing. For motions, the PSC rules provide 10 days to respond, and then parties have 5 days to reply to those responses. Under the South Carolina Rules of Civil Procedure number 6, time, the first day of service does not count. If the due date falls on a weekend, you don't count it, and if there's less than 5 days, you don't count weekends. Again, Duke's filing submitted on a Friday after close of business, I think amounts to litigation by ambush. DCA is effectively being asked to review, assess, and respond to Duke's proposal in a fraction of the time that our judicial system provides. Regarding the settlement testimony, the filing of testimony is governed by PSC Regulation 103-845, which states, In a proceeding involving utilities, the commission shall require any party in the Office of Regulatory Staff to file copies of testimony and exhibits and serve them on all parties of record within a specified time in advance of the hearing. The PSC sets the schedule with the specified times in advance, as it did in this case. Commission rules simply do not provide for settlement testimony. While the department acknowledges it may be helpful for the commission, when the settlement is not universal, it may prejudice other parties who do not join it.
I'm sorry, could you repeat that last part? I just didn't catch it. It may not provide.
So we recognize that settlement testimony can be helpful to the commission, but when the settlement is not universal, it may prejudice other parties in the hearing.
Okay.
As a contesting party, DCA is entitled to an opportunity to confront any witnesses in their testimony. The commission's rules acknowledge the complexity of these hearings and appropriately require pre-file testimony. However, the commission also appropriately issues a schedule to allow the parties and commission to assess those testimonies. The PSC schedules typically include a minimum of 7 days between rebuttal and surrebuttal and a minimum of 2 weeks between direct and rebuttal. So requiring DCA to review and assess over 330 pages of documents in 2 days is prejudicial. As I stated earlier, the time frame for replying to motions. Again, this is 330 pages long. It's about 10 times the length of a typical motion. Duke's motion to strike 12 witnesses' surrebuttal testimony in this matter is 25 pages long. The commission, I said the commission's rules, do not provide for settlement testimony. But as you all are aware, the commission has also published policies that address settlement procedures. The last version of that I'm aware of was revised on June 13th, 2006. The document includes a section 5 titled Settlement Procedures that does contemplate settlement testimony. However, section 5 begins by stating the procedures apply, quote, when all parties to a proceeding reach agreement. That is not the case here. Without admitting the testimony is relevant, and assuming it is, we think it should be excluded per South Carolina Rule of Evidence 403. That, due to a waste of time. Essentially, I'll just read you the rule. It says, although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, and then or misleading the jury and undue delay. We believe that's the case here. I won't rehash the schedule, but again, everything was filed, pretty much late in the day on Friday. So ORS's witnesses, one witness settlement testimony again came in at 2:04 on Friday. The department did review that testimony shortly after it was received. Again, ORS's witness generally explains the settlement, its impact on customers, and their support for it. Likewise, I mentioned Walmart. We reviewed their 3 pages, and they simply say they are joining or do not object to the settlement. So while we're in the midst of preparing for the hearing, that's starting on Monday morning on a Friday, we have not had time to review all of Duke's settlement witnesses. We did take the time to look at 2 of the witnesses. We began with witness Coyne, who's highly relevant to the rate of return issues in this case. In his settlement testimony, Mr. Coyne takes another opportunity to criticize the department's witness. He talks about Mr. Rothschild's shortcomings of his approach, that his inputs distort results, that he bases his capital structure on holding companies rather than utility operating companies, and he possibly added new information stating what the quote, current 30-year treasury yield is. The department also reviewed Mr. Callahan's settlement testimony because he typically provides an overview of all the other witnesses, and as its president, generally speaks for the company as a whole. However, his settlement testimony expresses his opinions on what does or does not remain in this case and is highly misleading. Among his other conclusions, he states his opinion that the coal ash issues are resolved in a manner reflecting DCA's testimony, and that the only remaining contested issues are cost of capital and certain grid improvement plan programs opposed by DCA. Again, I've not had a chance to review the entire settlement agreement, but I'm almost certain Mr. Callahan's statements are not true. More importantly, settlement testimony should not be used to attack the positions of other parties. It certainly should not be used to introduce new testimony or material. And again, while we have not reviewed the remaining testimony, at a minimum, it appears Mr. Coyne has done both of these things. I recall Mr. Coyne testifying in some prior dockets, so I went back and looked at the Piedmont natural gas case, which is a very similar situation to this. His settlement testimony there simply states why he thought the rate of return was supported by pre-filed testimony. We believe that is what appropriate settlement testimony is. Duke stated in its motion to strike the department's surrebuttal testimony that, quote, surrebuttal cannot and should not be used as a mechanism to simply get the last word on any issue addressed by the company. By the company, its rebuttal testimony, which interveners clearly do. It appears this argument does not apply to settlement testimony because, again, that is what Mr. Coyne has done and Mr. Callahan have done. So our final argument for striking the settlement testimony is that due to the extensive nature of the settlement and settlement testimony, they are essentially amended and are definitely supplemental pleadings. Amended and supplemental pleadings are addressed by South Carolina Rule of Procedure, Civil Procedure, Rule 15. I'm just going to read a couple parts of that to you. A party may amend his pleadings once as a matter of course at any time before or within 30 days after a responsive pleading is served. Otherwise, a party may amend his pleading only by leave of court or by written consent of the adverse party, and leave shall be freely given when justice so requires and does not prejudice any other party. The PSC Regulation 103-804-0 defines a pleading as a document seeking relief in a proceeding. We believe the analysis in Rule 15A should be the same for Duke's entry of settlement testimony, which we think amount to new pleadings, amended pleadings, and its revised procedural schedule. Just about done, but a couple notes on how our South Carolina Supreme Court has looked at the issue of prejudice and Rule 15. The case is Poole versus Poole. It's 329 SC 324. While that case was related to pleadings for sanctions under the South Carolina Frivolous Civil Proceedings Act, the court addressed Rule 15 in the context of a motion to amend pleadings and emphasized the notion that a party must be prejudiced by the amended pleadings. They said that is the focal point of inquiry in allowing an amendment of pleadings is whether a party is prejudiced. They stated prejudice occurs when the amendment states a new claim or defense which would require the opposing party to introduce additional or different evidence to prevail in the amended action. They stated that Rule 15 envisions a lack of notice that the new issue is going to be tried and a lack of opportunity to refute it. Stating, in considering potential prejudice to the opposing party, the court should consider whether the opposing party has had the opportunity to prepare for the issue now being raised formally. Based on the timing and voluminous nature of the settlement testimony, it is clear that the department lacked notice and has not had time to prepare to respond if needed and is prejudiced by the filings. So again, we would ask that the commission strike the settlement testimony, again, recognizing it has not been filed, but feeling the need to raise this procedural issue. And as an alternative, the PSC should delay the start of the hearing for at least 2 days to allow the department to finish reviewing the settlement testimony and determine if there are particular witnesses that can be submitted as is or if there are particular provisions that need to be struck. The PSC should also reject Duke's revised proposed schedule and witness list. And again, if you wish to hear from settlement witnesses, we believe they should be done standalone at the beginning or end of the normal hearing. We believe delaying the start of moving the start of witnesses to, in this case, maybe Thursday would allow a full day for us to review and the PSC to review the settlement testimony and revise our motion if needed. We could update the PSC by early Wednesday afternoon so that it can review.
Update by when?
With moving it back a couple of days would give us time to a full day to review everything and then update the commission by Wednesday if we believe that there need to be any revisions to this. But on that note, we believe that if you're going to move back the hearing any amount of time, that the proposed order deadline should also be pushed back. Essentially, by shortening the already compressed 6 months the commission has here, we're now moving everything back. We're playing it. We're moving back the shortening likely the time frame for preparing proposed orders and for the commission to prepare its final order. So we believe the deadline for the proposed order deadline should also be pushed back accordingly. And that's all I have.
Okay, thank you, Mr. Hall.
Chair, may I respond?
Yes, sir, but let me just say that the plan was to break for the day after preliminary matters to give time. I think that the DCA has raised an issue that they need more time. And I think that commissioners might welcome that time as well. So with that in mind, and also, I don't understand the proposed schedule that was filed Friday afternoon, asking that the DCA present their witnesses before all of the company witnesses. I think that's a no-go too. So with those things in mind, you can respond.
Chair, thank you. Let me first off say that was a lot. I will state here very clearly, I'm not here to prepare to provide a number of quotes to the procedural rules and the statutes. It's the first I'm hearing about that level of voluminous objections and issues. And so especially as I navigate through this, if I miss anything, I appreciate anyone letting me know because I'm absorbing this all for the first time. Just want to make that very clear right up front. Chair, the first thing that I will say, I find it quite interesting that the DCA is arguing a violation of due process. Last I checked, the government does not have due process rights. Who does, though, is the applicant, and that's Duke Energy. And so as part of the framework that we are proposing with this framework between what we have proposed, what we've laid out, and what we filed is all to ensure that the applicant has its due process rights with it, what we filed and what we're requesting and what we are seeking the commission to obtain. And we believe that we need all of the information into the record to be able to make sure that all of our due process rights are addressed fully and comprehensively. In addition to that, Chair, and respectfully from the framework, what the company has proposed with its order of witnesses is essentially the separation of direct and rebuttal testimony. So as part of the company's proposal, the company has, by nature of the fact that with the help and collaboration of multiple parties in this room, with the exception of one, being able to provide and propose a settlement that covers almost all issues in this proceeding. By nature of covering almost all issues between the majority of the parties that raised those issues, the company proposed for judicial economy and efficiency, with the recognition that we have 23 witnesses, that we would bring forward those witnesses that could directly address the settlement, that are essentially have resolved issues included, as well as being able to present witnesses that could directly address the remaining disputed issues. That is essentially what the company's proposed. And I think the chair and the commission and the parties heard that we also said in addition to that, we would make available any other witness that the commission or the parties would like to hear from. We are not saying that our witnesses are excused. We are trying to be a bit more efficient in terms of making sure that the right folks who can address those issues that may still be at issue by nature of what's been put before the commission are here and present and have a area and time frame that seems a bit more efficient. I also find that what's quite interesting, Chair and the commission, is that the company and DEP essentially did the exact same thing. In fact, as part of that proposal and that framework, the company was able to provide, just by nature of when that settlement was filed, I think even less time, unfortunately, to the commission, where I think that settlement literally came in as part of the initial day of hearing. And through that, and I fully acknowledge that that was a fully settled issue on all issues, but the company did file settlement testimony. The company did have a revised order of witnesses, and the commission was available and was able to provide any or request any additional witnesses to show up and appear either in person or virtually throughout that framework. So I don't see a difference here based off of what happened for DEP versus this particular matter. The only difference is that the Department of Consumer Affairs is not a signatory or does not does not object to the overall settlement. That's the only difference that I'm seeing within this framework. In addition to that, Chair, and the company certainly has no opposition if there's additional time requested for parties and the commission to review the settlement. Company has no objection to that time frame, but I do acknowledge two things. One, although I certainly cannot and will not walk through any of the negotiations that occurred between the parties, Mr. Hall himself indicated that he was actively involved in the settlement negotiations. And so I do find that a bit ironic as to his position here today. In addition to that, the company did file it on Friday. The company did acknowledge and convey to commission staff in a status conference with the all parties that testimony was going to be forthcoming post the settlement. So there was definitely notice in addition to the underlying terms themselves. Chair, a few other things that I wanted to make sure I highlighted. So Mr. Hall articulates that the company's settlement testimony is 300 pages plus. The company does note that about 250 of those 300 pages is actually one exhibit from one witness that has all of the pro formas attached to it to make sure that the numbers that are reflected into the settlement are accurate and has that information available to it. I do note that the ORS is taking a look at some of that information to confirm its accuracy, but that one exhibit provides about 70% of the company's testimony. So it is a bit misleading to articulate that the testimony itself is 300 plus pages. That is not accurate. It's one exhibit. Finally, Chair, the only other thing I wanted to mention, I believe there may be some additional things that I missed in Mr. Hall's walkthrough that I'm still processing. But I do note that the company did file its motion to strike DCA's witness testimony several weeks ago. I understand that the chair did articulate that that will be addressed in the final order. The company would request, as part of that framework, that the chair similarly address Mr. Hall's motion to strike settlement testimony at that, in the final order as well, as opposed to ruling on it right here and right now. And let me just see if there's anything else, Chair, as I'm thinking through it. Chair, I think those are basically the points. I think the company would propose, and so just going back to the order of witnesses, Chair, to articulate the company essentially what it's proposing is to have that.
Just a moment.
And so, Chair, just to elaborate on the company's proposal, it is a separation of direct and rebuttal. The opportunity to be able to, and the company does have, its understanding is it does have that right. In fact, I think when order of witnesses are required, the company has to specifically, as well as the other parties, has to state whether it objects or does not object to the taking of direct and rebuttal together. So that implies that there is a right to be able to separate its case between direct and rebuttal, which essentially is what the company is proposing. The initial two panels were to address the settlement and essentially present its direct case, and then the remaining two panels are to address specifically those issues that are remaining, at least from the perspective of the company, as to the DCA's objection. So it is truly the separating of direct and rebuttal, and that's the company's proposal as it pertains to the order of witnesses and what it has proposed in this case. Thank you.
Thank you, Mr. Robinson.
Madam Chair, may I have a brief reply?
Mr. Hall.
I'll try to be very brief. And again, I recognize Mr. Robinson had not had a chance to review, and that was the first time he's hearing it. Again, due to the short amount of time, essentially had no choice but to make it here. I do object to whatever, reference to the remaining disputed issues and the characterization or comparison to DEP. I mean, he said the only difference was that DCA did not join here and everybody did in DEP. That one difference is substantial. That's the primary basis of our concern here. I also don't want to get into negotiations, but since Mr. Robinson brought it up.
No, we're not getting into negotiations.
It's not substantive, but I just want to point to his point that we should know what's in the settlement. And that's all I'm going to address, that we should know what's in the settlement because we participate in negotiations. Negotiations involve term sheets and general overviews of issues. They do not involve 51 pages of documents that go into the details of it. I don't think that's saying too much about negotiations. I think Mr. Robinson would agree with me. That being said, that's why we need to understand what those details are to fully understand what are the, quote, remaining undisputed issues. If I did not mention, I did not mean to mislead the commission. If I did not point out that the settlement testimony was 54 pages and it was 275 pages of exhibits, that was in my notes. But if I missed that, I apologize. And the last issue I just want to briefly address is that this idea that separating the new revised proposed schedule is essentially just separating direct and rebuttal. That's not at all what it is. If you read it, I mean, it does do that, but it's putting up settlement testimony, then asking the DCA to put up its testimony. I recognize the commission has allowed utilities in the past to separate their direct and rebuttal. And I think if it wishes to do so here, we would not object. It has that, the commission has that discretion, but not in the manner that Mr. Robinson and Duke have proposed. And that's all. And again, I would just ask that we have some additional time to review the settlement testimony and the settlement agreement, and to address it. And actually, I'm sorry, I had one one more point based on Mr. Robinson's response. And I think this might be the best reason to delay it. He stated that the ORS is still confirming the accuracy of the 275-page attachment to the settlement. If they're still reviewing the accuracy, why don't we let them finish reviewing the accuracy, make sure it's accurate, and then we can all be on the same page as far as what the commission is being asked to review. That's all I have.
Thank you, Mr. Hall.
And Chair, just to state, as I said before in my initial, the company, to be clear, the company is not opposed to additional time. That is
Understand.
not the case.
Well, and we will do that. And I understand that, or my feeling is that this proposed order of witnesses is an attempt to move things along, and I recognize that it's such. It's just a bit out of the norm that I'm not real comfortable with. So we'll talk about that. Mr. Hall, I know we had we had a witness that wasn't available until Friday. Mr. Hall, do you think delaying until Thursday morning will provide you sufficient time?
I believe so.
Okay. We do have a commission business meeting that is noticed for 2 o'clock on Friday, so we will have a larger than normal gap. Thursday. Thank you. We have a business meeting scheduled for Thursday afternoon, so the lunch time Thursday will take a little bit longer. Is DCA in a position? Well, I mean, as DC, I want DCA to have the ability to continue to review the material and the testimony. Do you envision that you would be able to identify witnesses that may need to testify in person or virtually versus testimony that might be stipulated in, or is your expectation? I'm just trying to get a feel here that all witnesses need to be put up on the stand.
I have already discussed with Mr. Robinson this morning a condensed list of company witnesses that the DCA will want to cross-examine.
Okay.
And we can provide that to the commission if it's helpful. I know in the past the commission has also indicated to parties which witnesses they may or may not want to question. I can likewise have not talked with them this morning, but I had last week talked to the ORS about doing the same thing. Talked to Walmart about potentially questioning their witness. But I believe, yes, we can in the next today or tomorrow, we can certainly have a much condensed list of witnesses that need to be presented.
And I think that we're going to be working on a similar list, Mr. Robinson, so that if we can, I'm asking the commissioners to identify witnesses for all parties, not just Duke, but all parties of witnesses that commissioners may have specific questions for. So, I'm going to ask that the parties continue the discussion on the witnesses that need to appear and testify either virtually or in person. Commission will endeavor to do the same. I am going to grant that we will resume on Thursday morning at 9:30 with the hearing. Now, we do have a public customer hearing tonight. And I'm not trying to drag this out. I just want all parties and the commission to have the opportunity to be as familiar as possible with the settlement agreement and with other testimony that's before the commission. And similar to the motion to strike from Duke, where I said we would rule on it in the final order, likewise we will do that with the DCA's motion, oral motion to strike made here this morning. Okay.
Chair,
Yes, sir.
a question about the virtual hearing tonight.
Yes, sir.
So in terms of attendance,
Well, it's virtual.
virtual,
I think there may be one or two that are in person.
that's
think.
right. It's Chair, so I think that answers my
The
question.
the customer hearing tonight.
And I assume the commission will be here if the company would like to attend in person for the virtual hearing.
This is just like if we went to a out of town one. Yeah, please.
Thank you, Chair.
You're welcome to be here. Any party is welcome to be here. But this is a chance to hear from customers again. It's the last chance.
Chair Belzer,
Vice Chair Powers?
This seems like there was some earlier confusion about whether the hearing was 5 or 6. In case anybody's listening in,
It's 5 p.m. Starts at 5 this afternoon.
thank you.
We're talking about the customer hearing tonight. Starts at 5 p.m. Anybody else got anything to say about this? I don't want to leave anybody out.
Chair Belzer, if I may,
Ms. Mixon.
I'll just note we have witnesses that are traveling here, and we're planning to travel here in the next couple of days. We did not anticipate a situation where they would be testifying into next week, just given kind of the order of witnesses. And so we will need to confirm Jake Duncan and Stacey Sherwood's availability into next week, and would just ask that if necessary, that the commission and other parties may be flexible
Take out of order?
with their availability. We're not sure whether they have conflicts or not.
Right. Well, wasn't one of your didn't one of your witnesses
Stacey
was
Sherwood,
unavailable tomorrow or could
yes,
do-
Chair Belzer.
and could do remote on Wednesday or something?
She was available to testify remotely today, and was unavailable tomorrow because she was testifying in another hearing.
I think, my expectation, I think parties are always very accommodating with taking people out of order where there are conflicts, and I don't see why that would be any different in this matter. I see some heads nodding, but up and down, not side to side, so I hope that.
Right.
So
Thank you.
if that'll help you any, I would suggest talking to the other parties, Ms. Mixon, and thank you for bringing that to my attention. Anything else? Okay, so with that, parties, I know that going through these issues and taking our positions and I was in your shoes at one point that we get, we're each passionate about our clients' positions, and I recognize that. I appreciate the fact that the parties that appear before us are willing to work through scheduling issues, and I just encourage the parties to continue the discussion, as you've indicated y'all will, and know that you will, to identify those witnesses that need to be here and when. But I want to make very clear that my goal is to afford every party the time that they need and to prepare and present their case. I don't want anybody to leave this hearing feeling shortchanged, that they did not have the opportunity to present their case. That's my ultimate goal in any hearing. So you may not agree with some of my rulings, you may not like them, but I am just trying to make sure that everybody is afforded that opportunity to present their case as they see fit. So I may have to rein you in to match mine, but I do. I mean, I recognize that the utility has a role, the interveners, ORS, DCA, everybody has a role, and I just want everybody to feel like they've had a fair shot at being heard. That's the goal here. So I appreciate y'all working together. I appreciate you bringing these matters to our attention. Is there anything that anyone's unclear of where we are from this morning? That we're going to start back Thursday at 9:30. We usually notice the first day for 10. I like to start a little earlier, and we will move through. Thursday afternoon will be a little longer lunch because of the business meeting. We'll let you know about that. Friday, if we're still going Friday, which I anticipate we will, I'm not going to keep you till 5. We'll probably end about 4 or something because people need to travel, and then we'll be back on Monday as needed. So let's make our plans accordingly. Mr. Robinson, you look like you want to say something.
Madam Chair,
I'm going to go to Commissioner Thomas first.
I believe Monday's a holiday.
Monday's a holiday? What's Monday? Is it? All right. Well, that's not the next. Oh, it is. Okay. Well, then Tuesday. So, how we go? Mr. Robinson?
Yes, Chair, just for clarification purposes, so Thursday morning, How are you envisioning? Is that going to be the start of testimony, of witness testimony on
Yes.
Thursday? Okay.
I envision that'll be the start of witness testimony, and who goes first. If Ms. Mixon's witness has an issue that we all need to work out, we'll figure out who goes first. But otherwise, it would be the company proceeding first.
And Chair, as part of that, should the company and the parties expect any further clarification as to whether the company's proposed order of witnesses?
I think we're
Is
gonna.
accepted or
I
not.
think. Yeah. I think that the company is going to need to proceed. If you want to put up direct and then have DCA's witnesses and other parties' witnesses, if you want to split direct and rebuttal, you can do that. But I think you need to be prepared to put up the witnesses that are identified as needing to be in person. They're direct. I don't know that. I tell you what concerns me about the proposal is I recognize the cost of capital panel and grid improvement panel, but they've got direct and rebuttal. And to say that the first two panels from the letter, I'm referencing the letter from Friday, that these are direct, and then the cost of capital grid improvement plan panel are rebuttal. They've got direct and rebuttal, and I think you need to be prepared to put up. If you want to split, that's your right to put up direct and rebuttal. Okay. But you need to put up the direct witnesses that are identified, then we'll move to other parties' witnesses, and then come back for rebuttal. Or you can put up direct and rebuttal together. Okay.
Thank you, Chair. I
that
will note,
help?
sorry, I
Does
didn't mean
that
to cut you
help?
off. Yes, it does, Chair, and the company will plan to file a further updated revision based off of this information today. So thank you.
But I do appreciate everybody agreeing to, well, I think you have, to continuing to identify the issues. And if we have specific, if the commission has specific witnesses that we identify that we want to hear from, we'll have counsel email all the parties on that. So,
Madam Chair.
Mr. Torrey.
Just with the recognition that we're definitely going to be going into next week, I just wanted to echo what Ms. Mixon said. We may have, and again, depending upon which witnesses the parties and commissioners desire to hear from, we may have some scheduling issues as well. So I just wanted to let you know that, and we'll work with the parties to smooth that as much as possible.
Thank you. With that, we'll recess this merits hearing until 9:30 a.m. on Thursday of this week. And I don't even know what day that is. Was that the 23rd? Does that sound right? And then with the caveat that we do have a 5 p.m. customer hearing this evening. So thank y'all very much. Appreciate y'all being here this morning, and we will see you either tonight or Thursday. We're in recess.